You hear me, Pat?
Yes.
Okay. Justice, did you give me the key? Yeah.
Yeah, nice to meet you.
You as well.
So the screen will mirror the camera on. So, but the camera does follow voice, so I mean, if they did want to sit over there.
Oh, so the board members they won't be able to see the participants up there?
No, the only camera in the room is on that side.
Yeah, that's what they're.
So I was only able to reflect the presentation.
Okay,
Okay,
So,
well, should we maybe pull this out and sit on the other side of this table?
Would be pretty good too, because they can see you if you sit over there.
They'll be able to see us if we're there?
Yeah, the camera follows.
yeah, they're gonna see you guys, unless you want
That
to
makes
be on the, end there,
No.
but.
Yes. Because the camera follows speaker. Good. A plug for. Other side.
yeah, can you show us how we look to them?
Yeah, I'd like to see that
That
too.
would be nice to sort of confirm that.
Well, once I manipulate the screen
Yeah,
after we go through, the PM one.
okay.
So I'll change the layout either to,
Right now, the room is live,
right.
but, so yeah, right now we're unmuted.
Oh, we are mute? No, we're live. The
We're
mic.
live right now.
Hello? Can you hear me?
Yes.
Okay, because everything just went quiet.
Yeah, they're all muted for some reason. I think they're shuffling people there, Tom, over at the board in their room.
Hey, we got 20 cases today, man.
Yes.
Hey, Joy, once this is over with, can you please give me a call? Probably about 2 o'clock. Okay, Mr. Chairman, you can start with the preamble.
Okay. In compliance with notification requirements of Ohio's open meeting law in section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting has the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Call-in users can unmute by using *6. All meeting activities being recorded by way of the WebEx platform. These proceedings are also being live streamed by way of YouTube. All requests to speak on a particular matter by way of our website and email have been considered. We have also received emails from those who have provided written comment on a particular matter. Ms. Davis? Oh, we better,
Ms. Bradley?
let's go.
Well, Mr. Chairman, this is Dan Jacobson from the Law Department. Just some preliminary matters. Can we verify that the live stream is on and functioning?
Yes, verified.
Thank you. And Mr. Chairman, as the Law Department has done since these public meetings have gone virtual and or hybrid, law states its objection to the use of the chat function. Thank you.
Thank you, Mr. Jacobson. Ms. Davis?
Mr. Bradley?
Here,
Mr. Maschke?
Here.
Mr. Dink?
Here.
Mr. Gallagher?
Here.
We have a quorum.
Okay, we'll call the first docket is, actually, I believe we can, without objection from the city, we can open maybe the first two dockets. They're the same owner. So we have docket A 178-23, 3408 Warren Road, and building docket A 79-23, 3416 Warren Road.
These are notices of lead deficiency reports. A notice of deficient lead inspection report was received by this office for docket 178-23 and 179-23 on July 20th of 2023. Well, the date of the letter is July 20th of 2023. We accepted the appeal on August 21st of 2023. At the time, the request is that the city decision should be reversed and allow for a 20-year certificate of compliance be issued to both structures. Present for the hearing, Tom Vanover, Building and Housing, Dan Jacobson, Law. Will the appellant or his or her attorney or representative please state your name and your relationship to the property?
Ms. Davis,
Yes.
we also have Victor Santillo and Jenna Fryermuth on virtual to be sworn in as well, please. And that'll be the same for all the cases.
Thank you.
Will Dave be speaking as well? And Dave Roberts?
Will Dave Roberts be speaking as well?
Yes. Yes, okay.
We also have the chief of code enforcement,
Yes.
Dave Roberts, and present as well.
Is there anyone else?
Yes.
Okay.
Hello,
who
Mr.
else?
Gallagher. Good morning, Mr. Gallagher, the chair, and the rest of the board. My name is Richard Bain, B-A-I-N. I am an attorney at the law firm of Myers Roman, Friedberg and Lewis, and I represent a company called PB Free Ohio LLC. They are the assessors, the lead assessors retained by the property owner. And I am accompanied this morning by the owner of PB Free, Mr. Zachary Burkons, goes by Zach. And Zach, for all of these, for these appeals, as well as the remainder of this morning's docket, is the authorized agent to present these appeals on behalf of the various property owners, and contained in the files of the appeals are authorizations, notarized authorizations, appointing Zach with that authority to do so. Before I proceed, could I just verify that you can both see my face and hear my voice for these proceedings?
Yes, I can see you and hear you.
Okay, thank you.
Before you proceed, I need to swear everybody in, all the names that were given. And so we're gonna swear everyone in. Yes, raise your right hand. Solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay, we'll go ahead, and I guess, Zach, are you gonna be given to begin with, or to proceed? Or is it gonna be Rich?
I will provide an introduction to many of these cases, and as an overall sort of umbrella as to what we're here about, because there are two large group of cases that you'll be hearing today on the docket. The majority of them are owned by two separate property owners, the Saunders Group and the Gorlick Group. Some of the Saunders properties are owned by one of his companies, MF, as in Frank S. And but it's all Michael Saunders. The others, Mr. Gorlick's companies, fortunately on the docket, they're grouped pretty much consecutively to each other, so that we can handle a lot of these so far as the issues involved in those appeals pretty coherently for those property owners. There are a few other appeals that appear at the beginning and the end of the docket that are more one-offs, different owners, and we'll address those issues as we come to those particular appeals. But all of the appeals this morning are here this morning through the office of Mr. Burkons. There will be ultimately, I hope there's a rhythm to what we're doing here this morning and that things will go smoothly. The large body of the cases, the Saunders and the Gorlick cases, involve two themes that are going to repeat themselves over the course of the proceedings. With the Saunders particularly, those are cases that involve the evaluation of XRF sampling of the lead issues in these properties. And Mr. Burkons will describe to you what XRF is. It's an X-ray technique in which it, in a non-destructive way, pierces the surface of the material being X-rayed and identifies whether or not there is lead contained in it beyond an acceptable level. What we're going to be talking about ultimately with the Saunders case are the.
Mr. Chairman, I would ask, there are some running themes. But because of the number of cases, I would ask that as these get grouped together, that this testimony be presented and that we work through the cases as they come, and then so that the board can have a clear understanding of the indicia to each individual case.
Okay, so this, what you're describing, Zach, is something that's going to happen on some of these cases, but not the first two, correct?
Correct.
That is correct. Okay, so let's focus on the first two cases that we open, and we'll talk about that, and then you can go back over with your testimony when we get to those cases that would involve that type of inspection.
And then,
Yeah.
thank you, Mr. Chairman. One more piece of information on that vein. It's important that if the appellate decides and the board decides to bundle these cases together, that's within the board's authority. It's just important to the city that the record for the individual cases are maintained together. So that if there's need for further action, that the case record stands on its own and not as a group of cases that may be resolved today. Thank you.
Okay, thank you. That can be done.
Yes.
Okay, go ahead.
Thank you.
Zach.
Thank you. And in respect to Mr. Vanover's concern and comment, it is our intention, while they have a common theme, to individually present each case so that the record is clear regarding each property. So the Saunders cases will involve a demonstration of a lack of standards and ad hoc administration of test evaluation criteria for these
Zach,
properties.
let me stop you for a moment, Zach.
That's the attorney, Mr. Chairman,
Now, this is
That's
the
Mr.
attorney.
Bain.
that's the attorney. That's the attorney
you.
speaking.
That's the attorney speaking? Okay,
Yes.
I'm sorry, okay, Mr. Bannon, that's who's doing the talking now?
Right now, and I will,
Okay,
certainly until you become familiar with my voice, I apologize, I will identify myself since we're on the Zoom hookup as to who's speaking, because it may be difficult with this camera hookup for you to see that it's me speaking. So this is.
no,
Richard Bain.
I can see that it's you. I just didn't know between the two of you which was which, but that's okay.
Okay,
What I want you
I'm
to
waving
do.
my hand. This is Bain.
Yeah, no, we got you. Listen,
Okay.
what I want you to do is focus on, unless these are the Saunders cases, these first two,
Okay,
I want you
they're
to
not.
go back to them if you can. I know you probably have everything chronologically written down there, but what I'd like you to take on those two cases and leave the rest of them until we get there.
Yes,
Okay?
sir. I will
Okay.
do that immediately.
Okay.
The first two cases, which are 3408 Warren Road docket number A178-23, and 3416 Warren Road, docket A17923. Those cases can actually be handled together, and you'll see why in a moment. These cases are unusual on this agenda. In April of 2022, these cases were originally tested by Mr. Burkons, and there was a submission made by him on behalf of PB
Mr.
Freeman.
Chairman, Mr. Bate, if I could interrupt. Mr. Chairman, the city's records show that both of these properties have been issued the 20-year certificate. So we would ask if the appellant wants to pursue them or just withdraw them at this point as moved.
We are going to move to that, Mr. Roberts, but I
Okay.
think it's important that the board understand how we get to the withdrawal of those cases. The submission of these cases was when, Zach?
June 8th, 2022.
And what happened on June 24th, 22?
I received a call from Jenna saying 2 rooms needed to be addressed for the remediation of the one specific door part and the locker area.
All right, so you'd made a submission, she came back and asked you to do additional
Correct.
work.
Yes.
And on June 28th, what did you do of 22?
On June 28th, I received an email from Ms. Fryermuth that said the policy now is that dust wipes must be done in accordance with the XRF exams, which it was not prior to that. And we went back and forth on that. I just said, what about the ones that are already in? And she said, the ones that are in are okay. We can show you the email if you'd like. The ones that are in are okay, moving forward.
All right, and then in August of that year, which is, 4 months approximately after the original test, what did you do?
I submitted the retests.
Okay, and what happened in October of 22?
We received letters for approving the 20-year certificate for both of these properties.
Okay, so in October 22, you had approvals for both these properties. Let's skip ahead to July of 23, approximately 8 or 9 months later. What did you receive at that point?
At that point, excuse me, at that point, I received deficiency letters for these 2 properties saying that they were deficient simply because they didn't have the wipes, which were not required at the time of the test.
And did you communicate with Jenna or the board or the Building and Housing Department about that?
Multiple times.
And ultimately, and you explained to them that certificates had already been issued for these buildings?
Not only have certificates been issued, their rebates have been paid.
The rebates from the coalition had been paid.
That's correct.
Okay. Is the board familiar with the coalition? Do we need to explain that to you?
Mr. Chairman,
I am not.
if I may, sir, this is Vishnu. To the appellant, it's my understanding, correct, that the request that you've come forth with for the 20-year certificate has been granted, and you will ultimately be withdrawing?
Yes.
Okay, and in that case, Mr. Chairman, in the best interest of the number of cases we have and to move things along, I'll defer to you if they have already received their 20-year certificate of compliance, then what's in front of you to grant has already been granted.
Okay.
And if the board would indulge us for just really
Well,
one more
you
minute,
know
we're
what?
going to be concluded with this.
Mr. Bannon, I understand, and you will probably get a chance to redo this again as this goes down and I know what you're looking to do, but I think because of the time that if these 2 are already taken care of, then I mean, you will have a chance to go ahead and go back over, because there's another case that's probably pretty similar after this. And if you need to do that, then you can do it. But I think because of time, I would agree with our attorney that we should go ahead and take care of these 2 if they're already, as I think it was Mr. Roberts, you had stated that, made a statement there about these two properties.
Well,
Yes, Mr. Chair.
okay, I will wrap up then, Mr. Chairman, in light of those comments. When we left it, a deficiency letter had been issued essentially revoking the approval in September, and Mr. Burkans had testified he communicated about that circumstance in September of 23. What occurred, Zach? You received an approval?
The revocation of the letters. So now it was intact.
Okay, and with that said, the representation of the city that having granted the approval, revoked the approval, and then reinstated the approval, a year later, we are comfortable that 20-year certificates have been issued, and we withdraw the appeals regarding docket numbers 17823 and 17923.
Okay, Mr. Vano, do you have any comments?
Not at this time, Mr. Chairman.
Okay, very good. Okay, so, all right, so these have been withdrawn, so I don't think, there isn't any further action, if I'm correct with that from our attorney.
That is correct, Mr. Chairman.
Okay, thank you. All right, next, docket is gonna be A 218-23-2804 South Moreland Boulevard.
Application and fees are approved. This is also a notice of deficiency led inspection report issued on August 2nd of 2023. Appeal was received August 30th of 2023, requesting the board to reverse the rejection and issue a 20-year certificate. Present for the hearing, Tom Vanover, Department of Building and Housing, Dan Jacobson Law, Chief Robert
David Robert.
David Roberts, Law, with the appellant and his or her attorney or representative. Please state your name for the record.
I'm Richard Bain. Same law firm as before, Myers Roman. And I'm here today with Zach Burkans.
Okay, all right, all those giving testimony, raise your right hand, solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay, we'll go ahead and proceed, Mr. Ben.
Thank you very much. Saunders property?
No.
This is an interesting property because, and I'll take Mr. Burkans through it. What we are objecting to with this property board is the lack of standards and the arbitrary and capricious ad hoc administration of testing procedures in reviewing the tests submitted to it by the assessor PB Free. Mr. Burkans, I'd like to take you through the history of what occurred with this building. On May 10th, 23, what occurred?
We performed both dust wipes and XRF tests on the unit in this property.
And how did you, and on May 22nd, what did you do?
I submitted the reports pursuant to Schedule 7.3. We tested 20 out of the 23 apartments, both XRF and dust wipe.
All right. When you did the XRF test, how did you know how to prepare and submit the results of those tests?
In September of 2021, Ms. Freiermuth sent me an email, which we have a copy if you'd like it, that gave me a sample to follow. It's the sample for 12000 Fairhill Road, and that is what I followed.
All right, we would like to, is this the letter that you received from Ms. Freiermuth?
Yes, it says from her, how do you plan to print this report? This is the best format for me. Here is an example of what others have done.
And Ms.
Do you have a copy of that, Mr.?
Yes, we do.
And I'm handing Mr. Roberts a copy of that letter. And we'd ask that it be included in the record of this proceeding. So there was an attachment to what Ms. Freiermuth sent you,
That is correct.
and I'm handing you a printout. Is that what was,
That was what was attached, yes.
and what is this that I've handed you?
This is a sample from Ms. Fairmuth of how to do these and how she wants them reported. This one was done May 25th, 21 by CTG Environmental for 12000 Fair Hill Road.
Now, this was on a property that you were assessing?
No, she was giving me a sample of what she wants to see.
Okay. And in this sample that she gave you, how many units had been tested?
30,
And there were how many total shots?
1,340,
And did that produce an average of how many shots per unit?
44 shots per unit.
Okay. Let's go back to what you did. So when you, on this 2804 property, and here's the report that Ms. Freeman provided. And here it is, Mr. Roberts, if you want to see it. And we'd ask for that to be included in the record as well. Let's go back to 2804, Zach.
Yes.
On June 29th, 23, can you tell us what occurred?
I received a phone call from Mr. Santillo, a very friendly phone call.
Is that Victor Centia?
That is correct.
And who is Mr. Victor Centia?
He is one of the people that grades the exams at Building and Housing.
Okay, and I believe he's been sworn in as a
I
witness.
believe so, yes.
And what was the conversation with Mr. Centia? What did he tell you?
He said he's looking at it for a 20-year exam, and as he went through it, the only thing he found that was difficult was one particular swipe that was over the limit. He asked me to go back to the property, retest that, and send him the results directly.
All right, so the test had been submitted, and he asked you to go back and, excuse me, I failed to turn off my phones. My apologies. I apologize, board. I neglected to shut off my telephones before we started. Mr. Centillo had invited you after submission, and in fact, had directed you to go back and retest the property, unit 204, and resubmit it. Is that correct?
Retest the dust wipes on I believe it was one floor that failed in the kitchen area. He asked me to go retest the dust wipes. Would be the standard would be 4 more floor samples from throughout the unit and resubmit that to him directly.
And did you do that?
I did.
All right. And that was on June 29th, 23, that you had this conversation with
Correct.
Mr. Centillo? And did he tell you anything about what would occur if that passed?
He said, I'm looking at this for the 20-year and that this is the only thing that needs to be fixed.
Okay. And then in August, 2 months later, or a month and a half later about, on August 2nd, 23, what occurred?
I received a deficiency letter that denied the 20-year certificate for it because it said the XRF readings were insufficient.
All right, and then what next occurred?
The XRF results submittal are the same as the XRF results that were previously submitted and approved many times by the Building and Housing. This excels the XRF standards that were previously provided to me as a sample. And again, we've turned in the sample report.
All right, so was Mr. Centillo able to explain to you why the number of samples that he failed you because were insufficient?
I don't believe so.
All right, I'm handing you the deficiency letter that was issued on August 2nd. Could you read into the record what deficiencies were found by Mr. Centillo in his report?
Insufficient XRF testing for 20-year exemptions. All components must be identified in the XRF data report, unit diagrams, and visual assessment forms. Provide photos of typical unit finishes, components, and locations. A 2-year certification can be issued for this property. And it may not be, the important part is it may not be amended.
All right, so in June 23, he was telling you you could not amend it.
That is correct.
And this is after he had invited you
In August of 23.
in August of 23. And this is after he had invited you to go back, retest, and resubmit.
Just for that one, yes, he said, this is a 20-year exam. This is the only thing I see wrong.
Okay,
I have his exact words.
all right, let's go over his what he is saying did not occur in these XRF tests. He says there was insufficient XRF testing for 20-year exemptions. What standard were you aware of as to how many XRF tests you had to conduct?
44 per unit, which is exceeded here significantly.
All right, and how much was it exceeded?
I did 61.1 tests per unit in that building as opposed to the 44.
In the template that Jenna had provided you as to, this is what we're looking for, how many per unit tests were conducted there?
In the one she gave me, 44.
So you exceeded the number of tests per unit by how much?
About 50%.
All right. So that we're certain the board is familiar, can you explain what an XRF test is?
Sure. An XRF machine is a large piece of equipment that sees all the way through all the layers down to the substrate and accurately and quickly measures any amount of lead that is present.
And this is a handheld unit?
Yes, it is.
And before a test begins, you calibrate this unit?
Yes.
Okay. When, so like a radar gun, or that a cop uses?
As soon as it turns on, the first thing it makes me do is go through a PCS check.
Okay. So to his first complaint in the deficiency letter, that the XRF testing for 20-year exemptions was insufficient, you've testified that you actually tested 50% more samples than in the example pro forma that Jenna had provided.
This is correct. And I think it's also important for the board to know that this property had been completely gutted and rehabbed within the 18 months prior to the examination. There was not going to be that.
All right. His next complaint in this deficiency letter is that all components must be identified in the XRF data report. Can you turn to the XRF data report? And I'd ask the board, I want to be certain, you have available to you, and is it in the record already, the file that would contain things like the XRF report and the submissions made by PB Free regarding these lead assessments? That's in your record, isn't it?
Mr. Chairman, to the appellant's attorney, to confirm that, I'd like to hear from the city's representative, Victor Santillo, and/or Freya Muth, to verify what reports were submitted.
Okay, I just want to be certain that this record contains, internally already. So if this proceeding were not to terminate at this stage, that the record going up is going to have, everything included in that record.
To Mr. Chairman, to the appellant, the record that we have today, he submitted to us and not to the Department of Building and Housing. So I would ask if Zachary can come over here and look to see what you submitted to the board as the report that you are referring to.
Give me a moment. This was before it came to you, it went to Building and Housing. And there are 26 pages of XRF reports at 46 per unit.
So,
I think that's it. Starting.
Mr. Chairman, while we're doing this, let me see if I could help clarify this for everyone. In an appeal to the Board of Building Standards, the appellant brings to the board everything the board is to consider. Am I correct?
That's my understanding. I just want to make sure it's in the
My
file.
client, the Building and Housing led unit, they don't gather everything they ever have on it and submit it to the board. The appellant has the obligation to bring the documents he wants to the board. Am I correct?
to the chairman, to Chief David Roberts, that is correct. So Mr. Zachary just identified that the board does have in their record those reports that he just gave testimony to.
Okay. That's great. Thank you very much. Thank you for the board's indulgence in that administrative bookkeeping adventure we just went on. Zach, if you could refer to the file then.
Yes.
And the complaint in the deficiency letter is that all components must be identified in the XRF data report, unit diagrams and visual assessments. And that you're to provide photos of typical unit finishes and components and testing locations. First, were those items identified in the pro forma?
No.
That Jenna provided?
No. They were not,
They were not.
nor were dust wipes provided in there.
Okay. Did,
Mr. Chairman, to the appellant's attorney, for the sake of having the hearings go forward, would you like to hear a response from Jenna?
Mr. Jacobson, I'd like him to conclude because I have a response prior to testimony from the reviewers before we get to that.
Okay, thank you.
Okay, let's continue.
okay, so certain of these elements were not contained in the information that the Building and Housing Department provided you.
Correct.
Okay, so let's go beyond that. Were the components, what is a component?
A component is something like a wall, a window, a closet, a shelf, something along that line.
Okay, were the components identified in the XRF data report?
Yes.
And can you identify for the record where in that report they're identified?
I don't have the total number of pages in there, but if you go through the report, there's 26 pages of XRF data and it's 46 samples per page.
All right, to assist the board, I don't know if your camera will pick it up. In the report, this is the type of page you're looking for. That's the XRF report.
You have a copy from me?
You have it. And what it does in columns, it shows the lead result, in this case negative, the component, what is being tested, a wall, a window, a closet, the location of it, the side of the room, the substrate that's being tested, be it drywall or wood, and what room it's in, the living room, bedroom, etc. So you did, that is already contained in your report?
That is correct.
All right, so it's they say that those things need to be included, and is it your testimony they were included?
The only pictures that were included, which at that time was the only thing we were being asked for, were the 4 pictures of the exterior of the property. And they are included 3 or 4 pages from the end of the report.
You had never been advised that they wanted any other pictures?
No.
Did you provide the components and testing locations?
Yes, I did.
All right. So for this, I'm going to sum up now regarding this property, board. For this property, what we see is Mr. Burkans did comply with submitting an XRF lead assessment that was aligned with the format that had been provided by the Building and Housing Department. Were these all negative, these tests?
Yes, they were all negative. As I mentioned before, the entire property had been gutted all the way to the shell with new windows 18 months prior to this exam.
So this was a lead-free unit.
Absolutely.
He had complied with what had been required of him and suggested to him by the Building and Housing Department. He had submitted the test. He had exceeded by 50% the number of XRF samples that were necessary according to the pro forma and the example provided by Building and Housing. He had actually provided the information that were found deficient, except for photos of the unit finishes, which were not contained in the pro forma. But he had provided other photographs of the building itself as the pro forma had, or had in it. And yet he receives this denial when the building and housing representative, Mr. Centillo himself, had suggested and urged Mr. Burkans to go back and retest the unit and submit it after the original submission. Then turned it down, and I'll note at the bottom of the deficiency letter, it says, this inspection report may not be amended and a new inspection is required to document the correction of the observed deficiencies. So the only observed deficiency that you had not complied with, or it's already submitted, was a photograph of all of the rooms. Is that correct?
The only one that, yes, of this, the only, a photograph of each room in the property, which at that time, previous to that, had not been required.
And you had amended the report previously, but now in the deficiency letter, they say you can't do it anymore.
Correct.
And they also say in this that you have to start for the lack of the photographs that had not been requested or required before. They're saying start all over with the entire test. Is that correct?
The dust wipes as well as the XRF, yes.
And the dust wipes have expense involved with them, right?
Absolutely, labor as well as lab and materials.
I've concluded with Mr. Burkan's testimony regarding this, as well as the appellant's request that the determination of the board of the building and housing be reversed, and that a 20-year certificate be issued as a result of PB3 having complied with the requirements of the lead testing on this, and that the property owner should not be burdened with having to retest a building that is proven negative in all aspects of lead, simply because of the ad hoc, make it up as we go along approach that building and housing had and demonstrated in this report as to how many samples they wanted, still unidentified, even in the deficiency letter. Well, he already did 50% more than your requirement that you had promoted in your pro forma, and still there's some unidentified number, a target that he'll never understand what it is, but you haven't done enough. It makes no sense. It's discriminatory against this property owner. It is a violation of the due process rights of that property owner, and this decision should be reversed and a 20-year certificate issued.
Okay, I do have one question before we run over to Tom here in a minute. And that is that you did have a deficiency that occurred in your testing, and they were asking you to retest that area. Is that correct?
That is correct, and I did exactly word for word what was asked.
All right, and I'm wondering, because if everything was replaced that you were working on, how did that come up with a positive test on that?
Well, that's one of the inherent problems, Mr. Chairman, and if I could for a moment, dust wipes are not terribly accurate. They have a margin of error of plus or minus 5 micrograms. The limit has been reduced now by 75% from 40 micrograms to 10. I believe this came in, I can find the exact one, but I believe it came in at 10 or, 11 or 12. So it was the minorest of minor fails and probably well within the margin of error of these particular exams. It could have been tracked in by someone, it could have been tracked in by someone on their feet. There are other properties in that area, including right next door, that are really in bad shape. The lead from that could have blown in. There's a million different possibilities, or simply that the test is not accurate enough.
So you retested and that was clear.
Correct.
Okay, thank you. Mr. Vanover.
So, Mr. Chairman, and Mr. Bain, thank you. I do have a few, several questions. Beginning with, Mr. Chairman, to the appellate, Mr. Burkans, you are a certified lead assessor?
That is correct, sir.
Is that a certification or is a license, if you can?
It's a license by the state of Ohio.
So it's a license by the state of Ohio. So it's not unlike an engineer's license or an architect's license?
I
It's
can't
a
speak
license
directly
that-
to what those licenses are, as I do not hold them.
Right, so it's not just a certificate, there's a licensing body at the state of Ohio that provides you the license, right? That's not a license that's given by the city of Cleveland, correct?
That is correct, yes.
Okay, and I'm going to assume that comes with an education requirement and a training requirement as well?
It does, however, I would tell you the XRF is almost not covered at all in the training.
Well, but there is a training component.
There is a 40-hour training component and an exam.
A 40-hour, is that training conducted by the city of Cleveland?
No, it is not.
But it's a requirement of the state of
That's
Ohio, correct?
Yes.
Okay, and so the requirements that are covered in your training, are those requirements presented by the city of Cleveland?
The requirements. are
Individual, you
very-
said the XRF gun isn't necessarily covered very well, but the rules and the requirements for testing, for dust samples and how it gets tested, does the city of Cleveland write those?
No,
Can you tell us who does?
I believe it's the Ohio Department of Health through the Ohio Administrative Code. As also HUD.
Okay, so Ohio Department of Health and HUD. So for the purposes of the board, I want to, and we've had lead cases before us before. I want to understand that, make sure everybody understands that our requirements is that for the city of Cleveland is that the assessment and the clearance is completed, and then the report is provided to us. And so that, you know, of what happens following these HUD guidelines. So much like architectural practice or engineering, sound engineering practice, there's a set of rules not written by the city of Cleveland that are written by some other governing body. And then the design professional, the assessor, or whatever the case may be, the licensed professional is required to conduct their activity per those requirements and then submit them to us. I will also state that just to give the board some clarity, that a sample, and we do this often, I do this as the building official for design projects, but we provide samples of how things should be reported to us. However, the design professional, the licensed professional, is or should be aware that those any samples or documents or examples that are provided are for format, not substance. So similarly, you know, with architectural practices and even this, how it gets reported is the sample, but what the content of the report, as Mr. Burkans has already stated, that is defined by the Department of Public Health and the HUD guidelines. So to speak specifically to this sample that we keep referring back to of what is required to do the XRF testing, on the sample that Ms. Freiermuth provided you to use as a template for the format, how many failed dust swipes were on that sample?
I haven't counted up, but I don't, in fact, this person did not do dust wipes to my knowledge, 0. I'll look at it again. He did a couple of paint chips. Yeah, I'm looking at it right now.
Okay, so
Paint chips. Go ahead.
can you pass a clearance with a failed dust swipe, Mr. Chairman and Mr. Burkans?
No, you cannot.
Okay, so this was submitted with failed dust swipes on it, correct? That's
It
what
was
that.
submitted one failed dust wipe, that is correct.
Okay, so Mr. Chairman, I'll remind the board that our responsibility is to receive the clearances that are conducted under the rules of HUD and the Ohio Department of Health for us to simply review them, and they are pass-fail. So to that point, and there's going to be a lot of conversation of failed dust swipes that were submitted to the Department of Building and Housing, and when and how those can be retested. And our position is, and has always been, that the expectation is when a clearance is submitted as passed, that it meets the requirements for passed. All of the retesting requirements for failed work is all, the HUD guidelines go through how that gets remediated. It's no different than any other testing or reporting that, if a steel test fails on a job site, then it's remediated, it's corrected, and then the final passed report is provided through the special inspector to the department. And so how that gets retested and recertified, those are all under those guidelines. This is no different than that. HUD has a practice and a process by which you retest and what needs to be retested. All of that is expected to be conducted because our expectation from the city of Cleveland per our ordinance is a passed lead clearance. So we would, based on testimony alone, this clearance was submitted with a failed dust swipe, and to Mr. Burkon's own testimony, you cannot have both a passed clearance and a failed dust swipe. To move further into that, as I said, the sample is, as common practice, it's a matter of format, not substance. This is not the regulations on how many dust swipes per unit need to be conducted. The HUD guidelines do that. Based on this testimony, and Mr. Burkon's logic, one can take 44 dust samples of the same 4x4 square foot piece of a wall, submit 44 dust samples of the same place, and we are expected, under his logic, to approve it. That's not what the HUD guidelines say. The HUD guidelines are very specific in all the areas and all the sections that need to be tested and any other evidence provided. So the sample does not determine the substance of the report. The HUD guidelines, as Mr. Burkans has said, the HUD guidelines do that. And Mr. Santillo, his responsibility is to review to those HUD guidelines and state they tested all the sections that needed to be tested. And in this case, our position, and you'll hear this many times through these hearings, is that they did not meet the specific requirements that the HUD guidelines provide that need to be tested. So you can't just pick an arbitrary number based on a sample of a format and say, well, this is the number. I'm going to assume that the HUD guidelines do not say 44 samples per unit.
The HUD guidelines are silent on number of samples per unit.
Okay, but they're not the HUD guidelines are not silent on the areas that need to be sampled, correct?
All it says is all painted surfaces.
Okay, so Mr. Chairman, I'd like, we can discount the number and this sample that was provided as the be all end all for the number of samples, because based on our understanding of the HUD guidelines and Mr. Burkon's just current testimony, the number of samples is not codified, and it is not the city's requirement or authority to identify a number of samples. So the sample document that was provided, I'll say it one more time, is for format, not substance. And so we will, we will hold to that the number of surfaces, the specific surfaces required were insufficiently tested. This clearance was, I'm going to say fatally flawed, as opposed to saying fraudulent, because we've already heard testimony that you cannot both submit a cleared report and a failed dust sample. So that alone is a fatal flaw, and we would ask that you uphold the deficiency letter, and that you, because it was submitted fatally flawed, and the surfaces that are required by not the city of Cleveland, the HUD guidelines, were not properly tested. They were not tested to the guidelines, and therefore the 20-year clearance that as submitted is, and any other clearance really at this point, 2-year clearance it's not sufficient. So we ask that you uphold the notice of deficiency based on those terms.
All right, those are things that need to be responded to, Mr. Chairman. Mr. Burkans, as Mr. Vanover has testified to, And unfortunately, I don't know if Mr. Vanover was sworn in or not, was he?
He was.
Yes,
You want-
he was.
Okay.
Yes.
As Mr. Vanover has testified to, are there any number of samples identified in the HUD guidelines?
No,
There is a requirement regarding testing of painted surfaces.
that is correct.
Did you test all of the painted surfaces in this building?
I believe so. I tested exactly what had been approved in all the other buildings I did prior to this.
Mr. Chairman, we do
Can I
not
finish,
believe,
Mr. Vanover? Please don't
Absolutely.
interrupt me. Let me finish, please. Then
absolutely.
you can respond.
Go ahead.
Thank you. You tested the walls and the number of painted surfaces required under the HUD guidelines. Is that accurate or not?
Let me pull it up, but yes, I did.
And that's contained in your report.
In those 26 pages there, yes.
Let me show you the lead safe. And had you submitted previously to this denial reports that had the same format and criteria, the number of tests, et cetera, that had been approved by Building and Housing
Yes, and on at least 10, perhaps a dozen occasions
prior to this?
prior to this, I had submitted samples looking just like this that were approved.
All right, let me turn your attention to the lead safe certification application that is contained in the file. What is this document? What
This
is
is what I have to complete and attach to the exam, and it identifies all the particulars of that particular exam.
So it was Mr. Vanover's testimony just now that you can only submit a application when clearance has been achieved. Did you
That
hear
is-
him say that?
I did hear him say.
All right, let's turn to the second page of the lead safe certification application. Who publishes this application?
The city of Cleveland publishes
This is
this.
a City of Cleveland document,
Yes,
correct?
yes.
Go to that second page, and it has clearance examination findings. Does it give you an option of one or the other thing to choose from to check off?
Passed or failed.
Passed or failed? So the application itself is, when is it submitted when something has failed? Can you?
You can.
You can submit it when it's
Yes.
failed. It has actually a box to check off to submit it when it's failed.
And you will see that through a lot of these hearings today.
And
yes.
if it's failed, clearance has not been achieved, has it?
No.
And the fact that it's submitted as failed, in the past, the practice of the city of Cleveland had been to allow what?
They would either call me or email me and say, for example, as Victor did, I believe in following the law in this initial part, hey, you missed one thing. These are hundreds and hundreds of pages of strings of numbers. It is very easy to manually miss one when you're looking at strings of thousands of numbers.
And it'd say, go back and retest this one.
That happened not only on this one, but on many of the K and D properties. I certified 10 of those, many, many times.
And the city would then accept the retests, the remediation. If it retested and cleared, great. If it was simply a failed area, clearance area, it would have to be what, remediated?
It depends what it is. And in a lot of these situations, for example, the one here where the floor came in at 12 instead of 10, I knew that was probably within the margin of error. So I simply retested 4 floors, which is the standard as required by HUD, by the city, and by the Ohio Department of Health. And then I resubmitted.
And it passed.
It did.
All right. And then with this amended, so there would be an amendment to the original submission.
Correct.
In this case, a number had been missed.
Yes.
So you had indicated it passed, but in other cases we're going to see today, you mark it as failed.
That is correct. And about 10 of them.
And the practice of the city had been to allow you to go back and amend the submission.
That is
correct?
correct.
To have remediation performed if necessary, to retest, and to resubmit. That had been the practice of the city of Cleveland, correct?
Yes.
So their form itself anticipates that a submission can be made with a failure, correct? And not a clearance.
Yes, that is correct.
Okay, thank you. Mr. Roberts, do you have anything more?
Mr.
Mr. Vanover?
Yeah, Mr. Chairman, if I can just follow up, I need some clarity. Mr. Burkhan testified that he followed the process he had with all of the other buildings. Was it the process that you followed with all of the other buildings, this other 10 or more properties, or was it the HUD guidelines?
I followed exactly what was in the sample that was given to me. Exactly.
Okay, Mr. Chairman, that we're going, then our position is that the sample is not the HUD guidelines. As a licensed professional, Mr. Burkhan has a responsibility to follow the HUD guidelines, not based on what he's gotten, what's gotten through before, or what, this sample, as we are aware, is for format, not substance. So the expectation is that he follows the HUD guidelines. It sounds as if that's not necessarily the case. I would also ask,
Mr. Chairman, what
if I
Mr.
could finish,
Vanover has.
if I could finish without being interrupted, that would be great.
Sure, Mr. Vanover, proceed.
So, Mr. Chairman, finally, so there, it is accurate that the second page of our application, does, have check boxes for passed or failed. In this specific application, which box was checked?
Who's examining?
So, Mr. Chairman, I would ask Mr. Chairman, to the defendant, did you intentionally, was this an intentional submission of false information to
Absolutely
the
not.
Department of Building and Housing?
Absolutely not.
And Mr. Chairman, I'm gonna have to object. Mr. Vanover is not an attorney representing the city in this. He's a witness, and it is inappropriate for Mr. Vanover to attempt to cross-examine this witness. That is the
Okay.
role of Mr. Roberts. And with all respect to Mr. Vanover, Mr. Burkhan is not going to be responding to Mr. Vanover's cross-examination, who is not an attorney and is
Fair
not
enough.
appropriate to be asking these questions. And I would point out that he has made, well, I'll catch it on redirect. Go ahead, finish, Mr. Roberts.
Mr. Vanover, you want me to take over?
Yes, please, Mr. Roberts.
Okay, so just to say, we're not conceding that Mr. Vanover can't play that role at an administrative hearing like this, but for the moment, we'll go to me. So, Mr. Burkins, why did you focus on the fact that you want to get to 44 samples per unit if that's irrelevant?
I'm sorry, could you pose that again, please?
Why did you focus on getting at least 44 CRF samples per unit? Rather, if that wasn't the meaningful, you knew that wasn't a meaningful threshold, correct?
Okay, first off, it's XRF, not CRF.
Sorry,
Not a
XR.
problem, let's talk the same language. And then on top of that, I was following the sample which passed. and
No,
got a
but
20
why would you follow a sample
Because-
if you know and you're certified to follow the HUD guidelines?
Did you follow that?
I did follow the HUD guidelines.
Okay, and the HUD guidelines don't say you need a certain number of XRF samples, do they?
No, they don't.
And
They
yet
just-
you focused on making sure to get enough per unit of the XRF samples.
That is correct.
Okay, let me ask you, looking around this room, imagine that all the woodwork here is painted.
Hmm.
If I test that door and that door and that wall and that wall and that wall and that wall, have I tested everything?
In here, you have to test all four walls, the doors, carpets on the floor, so that doesn't need to be tested. I believe it does.
Is there crown molding?
There's crown molding and I'm not able to reach the crown molding, therefore I do not need to test it.
I don't see crown molding. I don't see crown molding in
Well,
this.
I'm sorry, I'm calling this a molding, this high level of wood here. What about the piece that's covering that radiator there? You missed that, didn't you?
It was not present in this particular subject.
And when you provide this, we have this, your example, you haven't marked it. It says bedroom, 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 bedroom. It doesn't say where in the bedroom,
It
does
does.
it?
Yes, it does.
Where does it say that?
Let me get to it. Okay, if you look at which page are you on, starting with what?
Page 1 of
Okay.
26.
Not only does it say bedroom, under component, it says wall and the substrate and the side, A, B, C, or D, from which the sample is taken.
Not the diagram.
Not from the diagram, right here.
So this comes, I think you said before, this didn't come with complete pictures, did it?
It was not required before that, and it's not required in the HUD manual either.
Well, how if Mr. Santillo is reviewing it, does he know where A, B, C, and D are and what you actually tested in these rooms if you didn't follow the HUD guidelines?
Great question, and it is here.
Objection. That is not an evidence that he did not follow the HUD guideline.
Do the HUD guidelines indicate you should tell the reviewer where you took the sample from?
And it does, yes.
And yet you didn't really specify for Mr. Santillo exactly where these came from, did you?
No, I did. It says wall, the side of the wall, the substrate. It doesn't get any more
Okay,
specific than that.
Mr. Chairman, I would defer back to Mr. Bain to do his redirect on this, and then I would recommend that we hear from Mr. Santillo.
Who is it
Or
that you
we'll
want
go
to hear
right to
from?
Mr. Santillo if you don't have anything more, Mr. Bain.
Yeah, I do have more, but Mr. Burkons is trying to find a document in the submission that will respond to your inquiry, Mr. Roberts.
In fact, now that I look at this, there are no diagrams because it was never required before. All of the ones I turned in previously for thousands of units had no
All right,
diagrams.
so, Mr. Chairman, if, I don't want to interrupt with legal argument. I want to go on quickly to Mr. Santillo, but I do briefly want to echo what Mr. Vanover was arguing. This is a process where both the reviewer and Mr. Burkins have the same HUD guidelines. And then he submits a report and it gets reviewed under those guidelines. So all of this talk about, well, I was never told that, that's not how it was done before, is not meaningful to your review of Mr. Santillo's denial of this particular report, which is based on the HUD guidelines. So with that said, I'd like to call Mr. Santillo.
Nope, stop.
Go ahead.
Mr. Santillo, if you could unmute and join us.
Mr. Chairman,
Mr. Santillo, can you come on the video or do you not set up for that?
I am.
There we go. Good morning, Mr. Santillo. And Mr. Santillo, you reviewed the report for 2804 Moreland
I did.
and you issued a deficiency letter, is that right?
I did.
And what was the basis for the deficiency?
In particular, the XRF tests that were missing components.
And can you tell the board what components were missing?
We see no entry for floors, baseboards, or ceilings.
And if there are no baseboards in a property, what does the assessor do to tell you that?
There is an excluded list that is in the report that identifies items that were excluded from the testing. Excuse me. For example, if a floor was not tested because ceramic tile was installed over it, that's considered an encapsulation, or so that would be excluded. But all painted components are required to be tested.
And so based on your review of this report, you did not see that all painted components were either tested or excluded, correct?
Correct.
And so under the HUD guidelines, you were required to deny the 20-year certificate, correct?
Correct.
Okay. Mr. Bain?
Yes, thank you. Mr. Santillo, good morning.
Good morning.
The city is obliged to enforce Code Section 365 pursuant to HUD guidelines and Ohio law, including the laws promulgated by the Ohio Department of Health as reflected in the Ohio Administrative Code. Isn't that correct?
I believe so.
And City of Cleveland cannot have requirements that are contrary to HUD regulations or other state promulgated Ohio health laws, can it?
The municipalities are allowed in the HUD, by HUD, as well as ODH, to have a more stringent rule.
But the city of Cleveland has never, the city council of city of Cleveland has passed a single ordinance regarding this, 365, isn't that correct?
Your Honor, I'm sorry, Mr. Chairman, to Mr. Bain, or to you, Mr. Chairman. I think the legal argument should be reserved for the attorneys. I'm not asking Mr. Bain to take
Okay.
Mr. Santillo through legal analysis. I'm happy to do that argument at closing at the end. Mr. Santillo is here testifying that the report was inadequate under the HUD guidelines, and he's just said why. And now it's Mr. Bain's chance to ask Mr. Santillo more about that.
Right, and that's what I'm doing, Mr. Chairman. Mr. Santillo is charged in his job to enforce 365. Isn't that correct, Mr. Santillo?
That's correct.
And as part of that charge, you need to understand what laws you're underlying 365 you are enforcing, correct?
That is correct.
All right. Now, in the HUD guidelines, there is no requirement regarding the identification of excluded components, is there?
There is.
Can you identify where in the HUD guidelines that is, Mr. Santillo?
At this moment, I cannot
Take your
go
time.
through the 800-page document to show where, but as a matter of industry standard, the
All right.
excluded components list is a integral part to the XRF investigation.
All right, Mr. Santillo, if I were to tell you that I had conducted a word search of the entire 800-page document for the phrase excluded component and it does not appear, would that surprise you?
It would.
All right. And if excluded components are not contained in the HUD guidelines, it is not an element that you can enforce as a reviewer and inspector, is it?
It's my contention that the HUD guidelines do require it. Their recommendations as to how to put together a lead-based paint inspection risk assessment together does include that language, does include examples of excluded components.
Okay. Is this as a result of your own review of the HUD guidelines? Is that the basis of your testimony just now? You've seen that yourself?
I have.
Okay. In your deficiency letter, you make no statement as to how many additional XRF samples need to be provided, do you?
I do not, except to say
And,
that they were.
okay, well, let me ask you this. The number of XRF samples is actually to reflect the painted surfaces in the building or room, correct?
Correct.
All right. Now, earlier you did instruct Mr. Burkans after your initial review of the submission, that the submission of May 22nd, you had a telephone conversation with Mr. Burkans, didn't you?
I did.
And in that telephone conversation, you pointed out to him that there was a failure in unit 204, didn't you?
Correct, but it should be noted that that failure was for a dust wipe and not an XRF.
Right, it was for a dust wipe and FRF. And you told
Correct.
Mr. Burkans in that telephone conversation that if that dust wipe, if that failure in unit 204 could be satisfied, you would issue the 20-year XRF certificate, correct?
That is incorrect.
And in fact, you've seen a transcript of your conversation with Mr. Burkans where you said precisely what I just told you, haven't you?
At the time of my conversation with Mr. Burkans regarding the dust wipe, I had yet to review the XRF readings and the rest of the report. In my cursory review, it seemed to me there was a document missing from the lab regarding the unit that had the failed dust wipe. But at that point, the review was not complete. So as a courtesy, Mr. Burkans was contacted. It's a very large property, and the one unit is the one in question. I felt that to simply supply me or the city with that document, I could proceed with my full review.
All right, but that's not what you even referenced in your conversation with Mr. Burkans.
Mr. Chairman, I'm going to object. Mr. Santillo may or may not have said what the future held. His duty, no matter what he said, is to review it under the HUD guidelines, and he's testified that he did that, and nothing Mr. Bain or Mr. Burkans has said has disputed that. They want to make this into a question of whether they were treated kindly and given a chance to fix things that were wrong. That's not why we're here. We're here to judge whether Mr. Santillo made the right call under the HUD guidelines when they did XRF, but not for every component. Components are missing. Now, I have a redirect for Mr. Santillo.
Can I finish, please?
Okay.
Okay. Mr. Santillo, and first let me say the point of this examination of Mr. Santillo, board, is not that he wants to be treated nicely. He wants to be treated fairly. He wants to be treated in a non-arbitrary manner so that he gets a statement and a report and a statement and a passage preliminary from the board, from the building department, and then something happens and he is treated differently than he has been treated differently in the past, and that other persons have been treated who appear before the board, the building department, for lead assessments. Mr. Santillo, let me call to you what you actually told Mr. Burkans on that date in June 29th, 2023.
Mr. Chairman, I'm going to object again. It doesn't matter what Mr. Santillo said. If he led Mr. Burkans astray with what he said, that's unfortunate. But when Mr. Santillo sits down to review the report, he needs to review it on the HUD guidelines, which is what he did. And if we're going to go down this road, then we're going to go all the way down it. And I'm going to ask you to let me cross-examine Mr. Burkans about his many, many communications to the city. And I think that will take up way more of the board's time than you want.
Well, what I think is important is that we have a full and fair hearing. And if you ever feel you need to ask a question, Mr. Burkans, that's appropriate and relevant to what we're doing, obviously that is. The questions I'm asking Mr. Santillo are relevant to the 2804 Southmoreland examination, in which Mr. Santillo said to Mr. Burkans, but what I have is a failed sample in one of the units. This is for the 20-year. So you knew when you were talking to Mr. Burkans, it was a 20-year exam, right, Mr. Santillo?
No, I did not. My review was not complete.
But you said to him, this is for the 20-year. Those were your words, correct?
Mr. Chairman, if I may ask what
I'm
document
going to
we're
jump in
referring
and
to.
say, if we're going to argue the law, let's argue the law.
I'm not
So
arguing the
those
law,
words-
sir.
no,
I'm
you're
asking,
arguing what those words mean. Read those words again to me.
this is for the 20-year.
So Victor Santillo knew that this was for 20 years. He would review it later to determine if it met the 20 years. He, as a courtesy, is pointing out the failed dust swipe so that can be corrected before his review.
Well, let's,
So no good deed goes unpunished.
no, let's
And
turn
then
to the
Mr.
next sentence.
Perkins hears what he wants to hear, which is, if I do what you say, I'll get through. If I give as many dust swipes as Ms. Fryermuth suggests in the sample, I'll get through. If
Well-
I do it in the same format, I'll get through. If I get Mr. Santillo the new dust swipe, I'll get through. It doesn't work like that. It's not a full court press where Mr. Burkins gets to come at Mr. Santillo and Ms. Fryermuth and try to get to the finish line. He has to get to the finish line in his report by himself and submit that, and it's judged under the HUD guidelines. So
Well, that's-
let's hear anything from Mr. Burkins about whether he tested the components that Mr. Santillo says he didn't test.
Well, let me respond to Mr. Roberts because he's teed something up nicely. Thank you. It's like
Oh, you're most
T-ball.
welcome.
After the phrase, "this is for the 20 years," said by Mr. Santillo, who is here under oath testifying, he says, "I mean, everything looks okay, but there's one dust sample in unit 204 that failed. I don't see a retest." So I give that to the board as what the testimony, what the actual statement of Mr. Santillo was, not a revisionist version today. Oh, but I wasn't talking about the samples, the XRF samples, because he says,
Mr. Chairman,
every,
can we
let me
ask how
finish.
this
I didn't
transcript
stop
got
you,
created?
Dave. Let me
No,
finish.
you're reading from what you say is a transcript. There's no testimony that.
Well,
that's
we'll
a-
get to that. Right now, I'm cross-examining your witness about it.
All right,
and,
I'm objecting, and I don't want
And
this
we'll
line
get
of
the
questioning to
transcript in,
continue.
which is part, this transcript
So,
is
Mr.
part
Chairman,
of
we need you. We're fighting as attorneys. We need you to make a decision to
this.
guide us.
Let me point, this,
We're just gonna be talking over each other until we hear from you, Mr. Chairman.
this transcript is
Mr.
part
Chairman,
of the
we're gonna
record.
need to hear from you, or we'll just be talking over each other.
But David, you know this
We're
transcript
just
is
gonna be
part of the.
talking over each other.
You're
Hold just a
interrupting me,
moment.
David. I'm not
Let the
interrupting you.
chairman tell us what he wants to do with this dispute, Mr. Bain.
Yeah, what I was looking at is that he was just gonna respond to what you were saying, but, and I understand what you're saying, Mr. Roberts, about, what the guidelines are, and that's what's gotta be passed here. So it doesn't really, I know in your opinion, make any difference as to what may have been said ahead of that. That's the controlling document here at the end is what is required.
Thank you,
So-
Mr. Chairman.
Go ahead and
So,
finish up and then we'll go from there.
Okay, and I will simply point out and make sure that the record is clear that the transcript I've been inquiring about from Mr. Santillo is part of the record that was submitted in this appeal. And Mr. Burkons will testify as to the accuracy, and we can even play the tape of the conversation if you would like. So Mr. Santillo, if Mr. Burkons complied with testing all of the painted surfaces, you're satisfied. Is that correct?
Are we talking about the missing components in the XRF testing?
I'm talking about in the property 2804 South Moreland. If Mr. Burkons had tested the required surfaces, painted surfaces under the HUD guidelines, that would satisfy your review and passage of this lead assessment, correct?
Correct, but
Okay, thank you.
not all painted components were tested. So I
Thank
was
you.
compelled to deny it.
All right, Mr. Burkons, I turn to you. Did you test the required painted component? You are an XRF trained person, right?
yes,
Are you an XRF trained person, Mr. Santillo?
I am.
Okay. How many exams have you performed?
Mr. Chairman, that's not relevant. Mr.
I-
Santillo is a state certified, he is a state certified, lead reviewer and lead assessor that works for the city. That's not relevant to the conversation.
And I agree with that.
Okay, I'll withdraw that, sir. Let me turn to Mr. Burkons. Did you comply with the HUD guidelines in your testing this unit?
I believe I did.
Are there any required painted surfaces you did not test under the HUD guidelines?
The HUD guidelines only say all painted surfaces. It does not describe which painted surfaces or how many. And as far as the comment that was brought up before with the ceiling, it was out of my reach. And I checked this with my instructor. I'm not required to test anything that is out of my reach.
Have you ever tested something out of your reach?
No,
Have tests that were similar, containing sealants, for example, been passed routinely by the city?
yes, and still are.
accepted by the city.
Yes,
Did, I was asking Mr. Centillo questions regarding a transcript of a telephone conversation. Did you make a recording of that conversation?
every call coming into my office is recorded.
Okay. And did you have a transcript prepared of that conversation?
I did, and I have the actual recording here.
Okay. The transcript that you submitted, appended to your appeal, is that the transcript of this conversation?
Yes, it is.
And it is a true and accurate transcript of the conversation?
Yes, it is.
Okay. When you look at
Mr. Chairman, may I add something here?
Yes, go ahead.
I'd like to add that at no time was I made aware that I was being recorded.
It's a legal point. So long as one party to a conversation consents to the recording, which would be Mr. Burkons, it's a legal recording. Sir, give me 1 second and I'll try to wrap up with this. No, that's. Mr. Burkons, when we've already established, did you make a review of the HUD guidelines?
Yes, I did.
Have you looked for any mention of a requirement of identifying excluded components?
Yes, I did.
And does that exist in the HUD guidelines?
No, it does not.
Have you done a word search of the HUD guidelines, 800 pages and plus?
Yes, for the words exclude, exclusion, exclusion list, exclusions. It appears, the word exclude only appears twice in the entire manual, neither of which relate to what we're talking about here today.
Did you at some point receive some instruction or advice from the City of Cleveland Building and Housing Department? They were requiring you to identify excluded components.
At a point in the future, yes,
And this was after this test had been conducted.
correct.
So if they are now saying that there is a requirement or a failure for you to have identified in this lead assessment submission excluded components, did that requirement exist at the time that you performed these tests or completed the report?
Neither from the HUD, the state, or anything I had prior to that.
Other than the City of Cleveland declaring this as a requirement, does it exist otherwise in the HUD or ODH?
No, it does not.
Handing you what is a response to a public records request that you made to the City of Cleveland regarding ordinance 36504. Could you read, please, what it says?
Please provide a written copy of any statute, ordinance, administrative rule, or policy the department has regarding timing of submission, return by B&H, policy on retesting failed samples included, but not limited to to quantity of retest, date elapsed from original submission date. If there is a written policy, please provide a copy of the policy and the date it was announced and made current. Thank you.
And you made this request when?
I've made it several times by email to Building and Housing, but I got no response. I made this request on August 4th,
Okay, but prior to that, you had made.
many, many times.
All right, and did you eventually receive a response?
After filing suit in the Court of Claims, yes, I did receive a response.
And when was that?
That was the 19th of this month, about 10 days ago.
All right, and what was the response?
The city has reviewed its files and determined there are no records that are responsive to your request.
Thank you. And this document, public records request and the response are also have been submitted for inclusion in this file already. Right?
Yes.
Okay, so what you're saying here is that you've met the Ohio guidelines and that there isn't anything else to be tested. And the city is saying that it was deficient and that you didn't meet those guidelines. That's what I'm hearing. So if there's
Yes, in some unidentified, some illusory and unidentified something is missing from the report, not identified in the deficiency letter. Just, you're missing stuff. Mr. Burkons has testified, I've done everything to comply with the HUD guidelines. The city has presented no evidence. What HUD guideline was not complied with?
Okay, let me go back to Mr. Robertson and see what there is.
Thank you, Mr. Chairman. Mr. Santillo, if you could come back. You gotta unmute, Mr. Santillo.
He has to unmute. There he is.
Sorry
All
about
right,
that.
Mr. Santillo, once again, you rejected this report because there were not enough XRF locations tested. Can you name some of the locations that weren't tested?
Ceilings, floors, and baseboards.
I'm sorry, over the speaker. I couldn't
Ceilings,
hear what-
floors, and baseboards. Is that right,
Ceilings.
Mr. Santillo?
Correct.
In
Floors.
particular, baseboards.
Yeah.
Santillo, are there HUD publications in addition to the HUD regulations? Called guidance?
There's several guidance documents on a whole number of issues regarding testing.
Okay, and you were accused by Mr. Bain of being arbitrary toward Mr. Brookins. Do you review reports from other lead assessors?
I do.
And do you look at a similar XRF testing to see if it captures all components?
I do.
And if it doesn't capture all components, you give a deficiency letter, right?
Correct.
Doesn't matter who the assessor is.
No,
And have you had other assessors who provide the XRF with all the components, or where components are excluded, they let you know in some fashion that they've not tested those because they're excluded? So you are doing your
No.
typical review based on the HUD guidelines.
correct.
You saw missing components that hadn't been tested, and that caused you to issue the deficiency letter.
Correct.
All right,
Yeah, it's not.
thank you, Mr. Chairman. That's all I have.
So I do have one question, Mr. Santillo, is that what was kind of deficient in this was under Ohio law, or was it under a provision by the city?
It's HUD guidelines, which was adopted by the Ohio Department of Health. And we consider that the industry standard for lead testing.
Okay, and you're saying what wasn't tested where he claimed that he can't reach the ceiling, said he didn't have to do that because he couldn't reach it. And then there was baseboards, and what was the other one?
Floors.
Floors, okay.
Floors.
And that's what was missing, those three components from being able to have a complete for that standard.
Right.
So, okay, that's what I'm hearing. Okay,
Mr. Chair?
Yes.
Let Mr. Burkons clarify one thing. The complaint to Mr. Santillo was ceilings, which Mr. Burkons has already testified is that the test things he can't reach. Baseboards in particular is what Mr. Roberts pointed out. Mr. Burkons, were there baseboards in this room?
I cannot remember, to the best of my knowledge, whether or not there were baseboards. However, he also mentioned the floor. It was all vinyl covered flooring, not subject to testing.
okay, and let's see, we said base.
And you don't believe there were
flooring.
baseboards?
I do not believe so, but I've seen so many apartments, I can't keep track, to be very frank.
But
Okay, Mr. Vanover has a question. I want to bring him in. You got to unmute, Tom.
Just a final statement regarding procedure, Mr. Chairman. And not to get into specifics, I just wanted to point out that it is our position that any action outside of the HUD guidelines is arbitrary. So our requirements are to follow the HUD guidelines. As with anything, the Department of Building and Housing, we speak through orders. There's a lot of conversations has been a lot of conversations regarding this transcript and this uncorroborated piece of evidence. But the reality is, Mr. Roberts, as Attorney Roberts has already said, we speak through our orders. And that's whatever, it happens in the conversation. The reality is the rules and the law has to be followed, and anything outside the guidelines is arbitrary, which is why our expectation is to follow the guidelines. And, there's a lot of testimony in here about areas that do not need to be tested. Without being experts on the HUD guidelines and having that documentation actually provided, that's the whole conversation about excluded surfaces that we've been talking about. The guidelines say all painted surfaces, but yet there were many surfaces that were not tested. There was no exclusion report provided for us to determine that they don't need to be. You can't have it both ways. That's the expectation of the review. So we again ask that you uphold the notice of deficiency as properly issued, that it was given per the guidelines, that all of the areas were not tested, and that you uphold it and remand it back to the Department of Building and Housing.
Okay, let me get back to the board members. We'll go to Mr. Dank.
Mr. Chairman, this one, we've been talking about this for a lot of time now. If the testimony is isolated one from the other, both seem logical and reasonable. And if the goal is to get to an accurate, a complete conformity assessment and report, that seems a reasonable goal and common sense. In the testimony, it seemed to me the appellant had an intent to comply with the requirements as they were communicated and understood. And I can understand the complications of an 800-page HUD standard. So, and maybe Mr. Santillo misled, without an intent, without a malicious intent. So as I sit here now, I don't understand. We have a report. If there's an exclusion, an accurate exclusion for floors and baseboards, does that satisfy all of the groups? Does that allow the report to be satisfactorily submitted? Does that give Building and Housing a chance to make an accurate review? And has all of this been a lot of activity for the simple goal of getting to that complete and conforming report?
So what you're saying is that possibly that needs to be reviewed, that the areas that he's talking about, the floor, and if there aren't any baseboards, and the fact that the ceiling is way too high, it could all enter into this to making a difference in how Mr. Santillo would respond. Now, I see Mr. Santillo has his hand up, and maybe that's been done. I don't know. Go ahead, Mr. Santillo.
Mr. Chairman, I would like to add that subsequent reports submitted by Mr. Burkans for 20 years that I have reviewed do now include ceilings and floors and baseboards. And it's as early as yesterday, I reviewed one of his 20-year reports and approved it with those components all included.
And that would be because the city's requirement of identification of excluded components came after this test, right, Mr. Santillo?
No.
Mr. Burkans, yes or no?
That is incorrect.
Have you sought, since the city issued its excluded component request, have you complied with that?
To the best of my knowledge and ability, yes.
All right. This test was prior to that requirement being.
Yes, it was.
Okay.
Mr. Chairman, that is not a City of Cleveland requirement. That is a requirement in the HUD guidelines for putting together a late inspection report.
That is correct. I think
It's simply not correct. That's a legal argument, but it's not correct.
Mr. Chairman,
Well-
I don't know, are you declaring that we're done? Or are we continuing to argue?
Well,
No,
well,
I'm not arguing.
Wait a minute. I want to hear, I have to make a statement here first off, because we lost one of our board members. So we only have 3 board members, which means that if our decision is not unanimous, which it usually is, then your appeal goes back to the city. If for that reason you prefer not to have your case heard, then let me know when we call your case that you would like to reschedule your case. Now, we're in the middle of this case, so I want to hear from Mr. Bradley and get his opinion.
My opinion is that I'm not familiar with this. He didn't do all the testing, and it needs to all be tested before we can make a decision.
Okay, so it's right now you're considering that it's insufficient what has been brought in and there needs to be more testing. Is that what I'm hearing?
Without a doubt.
Okay,
Mr. Chair and board.
yes.
If the board would allow, Mr. Burkons is, as he offered previously to the city, is very willing to go back and test, now that it's been identified, this is the first time we've heard this, what is identified as the untested areas it wishes to see tested. Burkons can go back and do that. That's not an issue. And that's the XRF test. Not to redo, as the city is demanding, that the entire test begin from the beginning again with all the dust wipes, all of the 1,000+ XRF samples already done for the component areas that have been identified by Mr. Santillo today. Mr. Burkons is more than willing and pleased to go back, test those areas if they even exist. He doesn't even know if there is a baseboard in this property, but go back, test it and report it back, have it be amended to the report, and let the report be reviewed and considered by the city and passed.
Let me get to Mr. Roberts, and you heard what he has said. What's your response?
Mr. Chairman, there was nothing preventing Mr. Burkons from retesting that building and submitting a report prior to today. There's nothing to prevent him from retesting that building and submitting a report in the future. Now, to the extent to which he needs to redo testing, that's an issue that will come up when his report is reviewed. We're not willing to have a order now about the scope of that.
Well, that is.
In other words, we're not willing to say, go back and just do the baseboards. He's got to go back and do the baseboards if they were missing, do other surfaces like the floor or exclude them. And then he's got to provide the report per the HUD guidelines and submit it to Mr. Santillo or Ms. Fryermuth to be reviewed. He had that power all the way from when he got the denial letter until today. He has that power going forward. But what we're asking you to do is uphold the decision to deny the report that was submitted as deficient because not all the areas were tested.
And it's unfortunate that the city is taking that position, because this is more in the way of, just dragging this out. Because in the deficiency report, although previously in many other reports in 21 and 22, and this one, when Mr. Santillo encouraged Mr. Burkons to go back and retest that one area unit in 204 and amend and submit, it was permitted. And now in this deficiency letter for the first, it says the existing report may not be amended and a new inspection is required to document the correction of the observed deficiencies. So unless that was not the circumstance, that is not the HUD guidelines, that is not the OAC, which encourages people to test and retest until clearance is achieved. This is an independent Cleveland imposed rule that misconstrues and is contrary to the OAC and the HUD guidelines, saying the report may not be amended. That was not the practice of the city of Cleveland in the past. It is creating an impossible hurdle for property owners and an expense that is unfair, that property owners would have to, rather than abide by the HUD guidelines and keep remediating and testing until clearance is achieved. Instead, go back to the beginning and redo it again every time. This is, incredibly unfair to the property owners, and it should not be upheld by this board.
Mr. Chairman, if I could be heard on that, a lead clearance examination is a snapshot in time. You go into a property, you can use the XRF or dust swipes. You do a visual analysis. You see if there's bare soil outside the property. You see if there's any peeling paint. And that's your snapshot in time. Now, if you find a lead hazard, because the dust swipes come back, you do, under the HUD guidelines, have the opportunity to see if perhaps that's not a hazard, but is just the presence of lead dust that was insufficiently cleaned. So you clean again, and then you can bring your report if the retesting allows it. This does not mean that months and years later, you can say, well, for my snapshot in time, I want to use some of today's snapshot, and I want to go back to testing I did months ago and use that as part of my snapshot. Things change. The dust that gets tracked into a house from bare soil may have lead in it. So you may have lead in it that didn't exist 8 months ago. You may have altered some of the property inside by scraping the paint, painting, replacing a window. That's going to disturb the lead dust, and now your snapshot is no good. You have to do your snapshot again. And so Mr. Bain is incorrect that this is some kind of burden. The HUD regulations give you a snapshot moment, and you have to bring the result of that snapshot moment. But the good news for Mr. Perkins is the chance to do that snapshot doesn't go away. You can go back and you can retest, and then you can show that it clears. So you should uphold Mr. Santillo's denial, and then the ball goes back to Mr. Perkins. He can go retest that building, cover all the surfaces, the floors, the baseboards, make sure no dust wipes are negative. Bring that report in, and then he'll get compliance for his client.
So
Well,
it is stating that all components must be retested. Is that?
Hello?
That's not in the HUD.
That is not the HUD guidelines, sir. It is not. Mr. Roberts tells a
And
nice
Mr.
tale. Let me finish. Mr. Roberts tells a nice tale, but it is contrary to the HUD guidelines. The HUD guidelines specifically call out for retesting until clearance is achieved. The OAC, the Ohio Department of Health guideline, calls for retesting. It does not say, oh, and when you're done with that retesting and clearance of the failed area, oh, some time has passed, you must now go back and redo the whole place again. That is never said in the HUD guidelines or the Ohio Administrative Code. And neither is there any even City of Cleveland rule, as we saw in the public records request response, that such a thing occurred. There is no such rule. That would be an arbitrary, ad hoc administration of the program that is not found in law. And as the building official has pointed out, Mr. Van Over, they have to abide by the HUD guidelines. They have to abide by the OAC. They can't make up their own rules. And that's what they'd be doing there by saying, oh, you've now cleared the failed area. Well, now you have to go back and start all over. That rule does not exist. And they can't impose it on property owners, that property owners need to now start from zero and redo it.
Mr.
All right,
Chairman, I'm willing to concede Mr. Bain has a good legal argument there. My point to you,
Chairman,
that's not in front of me.
and this,
If you uphold the
time
notice,
need to go on and work. We've already asked to remand it to the city. Thank you.
okay. Mr. Chairman, if I could very briefly, I understand Mr. Bain's argument. I think that could come before you later if Mr. Perkins submits a report and it includes testing prior. The city says, no, that testing's too old. He says it isn't too old. He can appeal that. That would be squarely in front of you when it gets here, but we're not here on that issue today. What we're on today is whether Mr. Santillo was correct to find a deficiency when not all the surfaces had been tested.
The question is, we can order that, but what does he have to retest? What is deficient or start all over?
He has to submit a report, Mr. Chairman, and in that report, he can put in testing he's done previously, and we will evaluate that subject to the HUD regulations as to whether that's sufficient.
Okay, I just want to point out that Mr. Burkon's offer, I want to be clear for the record, to go back and test these components, baseboard, et cetera, that Mr. Centillo identified. That was a compromise offer to resolve this matter, this appeal. It is not a concession that Mr. Burkons has not already done everything required under the HUD regulations. He has not done everything required already under the, and in compliance with the pro forma, the example provided him by the city, which does not do these things that Mr. Centillo is now saying needs to be done, such as identification of excluded components. That is an after-the-fact imposition of a new requirement. That was not in the pro forma that the city provided Burkons as to this is how it should look, this is what you should do. He has complied with everything.
Okay, I'm hearing what you're saying. Mr. Dank?
I'm sorry, sir.
Mr. Chairman, Mr. Vanover has his hand up.
Oh, okay. I don't see him on here. Mr. Vanover?
Mr. Chairman, I think he put it back down.
He put it back down.
Okay, Mr.
I think
Dank?
I'm done. You done?
Mr. Chairman, I'm sort of stuck on thinking that it's reasonable to identify the exclusions for a complete understanding and a presentation of the report. I'm not compelled to think that previous testing that was done, even if it's some time ago, I understand Mr. Roberts' argument that things do change, but I don't know that they change. I don't know that they change that dynamically to make them obsolete as submitted in this report originally. So I'm inclined to think that resubmitting, clarifying what's excluded, retesting anything that might need, testing anything in the way of floors or baseboards that might not have been properly tested originally. That to me sounds like a reasonably satisfactory exercise that should resolve this.
So, Mr. Chairman, I apologize. I was muted.
Okay. Tom, you gotta.
So to Mr. Chairman, to Mr. Dank's position, the conditions, to get back to why we do this work, the conditions of lead hazards and lead, the toxicity of the existence of lead is why we do this. And this is, it's not new, and it's not a new method of doing things. I like to speak in analogies. This is no different than doing a structural evaluation of a building and waiting extensive periods of time outside of beyond the initial tests. One cannot just go back and retest one steel I-beam and just grant an opinion based on an old test of what the supporting structure's condition is. So our position is that, and this is an economic argument. I want to make sure that the board is clear that the only reason to not submit to us, which is the one thing we require a report of a clearance, and they provide the opportunity to tell us whether it passes or fails. Our ordinance, our laws require a passed lead clearance for all rental property. This was submitted as a passed clearance. However, we still contend, and the defendant is wavers back and forth, arguing that they believe that they've tested all of the areas, but if they didn't, they're willing to retest. These are all economic arguments that do not protect the customer, that do not protect the tenant to the customer. The expectation is that we simply receive what the law requires, and the law requires a passed clearance. So piecemealing it based on, submitting the report, and then we deny it, and then they go back over time and time and time. And when this is completed, this structure will not be lead cleared. By piecemealing it together, it will not be lead safe. It does not meet it does not, in our opinion, does not meet the content of the ordinance, but it most definitely does not meet the intent. And the intent of the ordinance is to require landowners that are renting their property for profit to assess the lead hazards and clean the lead hazards and get them cleared, not just stretch it out over pieces of time because we'll see what we can get past the city and just piecemeal it together. So at minimum, it does not meet the intent of the law, and it does not protect the persons that are going to be renting these properties. So we, again, will object to the ability to just go back and piecemeal things together. We want a clearance that is factual. When they submit it as a past clearance, this is everybody that submits. They test all the surfaces that their license requires them to do so, just as any engineer would be required to do the work that their license requires. They factually present us with the truth that it does not pass or that it does pass, and that we receive a cleared report.
Yeah, and Tom, I believe that if they go back and if those areas are identified with wherever they're at in there, not just that last one, but if they didn't do whether they had baseboards, but the flooring in different areas, then they need to do that. And that could be all over the place in there. I'm not sure. But I would say that it's a snapshot. They could be done with this and come back a year later and find, lead in the building. There's no question. It can be kicked up somehow, dragged in somehow. And it's a snapshot in time. I think that's been mentioned here before. So if they have gotten to having a lot of it that was good, then that's for 20 years. So I think that they need to go back and they need to, whatever it takes to clear this up by maybe extra testing on different things that, they weren't tested before. I'm not sure. But I think I'm inclined to uphold the notice of deficiencies based upon not being complete and having areas in there that need to be done, need to be taken care of. But I also feel that they just need to resubmit back on the areas that can be identified as areas that may have been missed in the first report, such as floors. I don't know that they can get the ceilings, but I think in those areas that weren't on there, then I think they need to do that. Go ahead, Mr. Vanover.
So, Mr. Chairman, I'll restate, the argument, there is no exclusion report for this on what they didn't test. So we know what the HUD guidelines are, and we have opined on that. So this is a matter of the city doing the work for the licensed professional to explain to them what they're required to do, and then them only responding to that. That is contrary to what the guidelines say. I will finish with, there is no other precedent for a licensed technical evaluation, whether it be structural, mechanical, civil. There is no other precedent that allows piecemeal pieces to be re-reviewed, re-inspected in a bubble, isolated from other components. When the entire system itself, the entire process, the entire space, all influence each other. Thank you.
Mr. Chairman, I have a question for Mr. Burkans, if I could.
Yes, sir.
Mr. Burkans, as a licensed professional, do you have a liability if I as an owner hire you and you give me a clean lead report?
I do, and I carry insurance for that.
Okay.
Okay, and once again, you could come back at a different time and maybe find lead there.
Yes,
So
that's true.
that's just one of those things that, and that's the reason why, I feel that, you've had stuff that's passed that's there. You can go back and find lead now. yeah, it's possibility. I mean, there's a lot of homes in Cleveland that have, not to get off on a tangent here, but have lead water lines that come into them. And, you know, nobody wants to do anything with that because it's way too expensive. Again, it's probably economics, but, you know, we're kind of making a deal of this, and I get it, especially when there's children in a home or that. But I believe that if the other places, what they've done already has already passed, my opinion is that they go back and they take care of this part that didn't. And whatever they were rejected on, they got to go back and they got to retest that and send that in.
And that would be satisfactory to, so is it your opinion, Mr. Gallagher, that he need not go back and begin the test over? Let me just recall the testimony where we're talking about this specific building, this unit, where it was testified, this place was gutted. Everything is passed clean. He'll go back and retest these ones, and that would be satisfactory without having to start from zero again. Because these are XRF tests. There's not even anything disturbed doing the test. It's a benign test of the X-ray shot. And if it passes, there's nothing else to do. There is no disturbance. There's none of these, assembly of horrors that have been described by some here. And I would again emphasize there's been testimony both ways, but that somebody has to, on behalf of the board, their counsel or whoever, evaluate the HUD guidelines and be able to advise, I think, that the word of the, what's the word, exclusion? Excluded components does not exist in the HUD guidelines. It's not there. This is a made-up requirement by the city of Cleveland that Mr. Burkons, as he testified, has tried to comply with in his subsequent tests after they imposed it. At the time of this test, there was no such imposition of that Cleveland requirement. So if we can do what Mr. Gallagher has described as a satisfactory conclusion of this individual appeal, test those things, he can provide that excluded component report if there's anything to be concluded on it to the city, and if everything passes, that we're done with this property. That for the 20-year inspection. That would be a satisfactory conclusion.
Mr. Chairman, if I can reply to that.
Go ahead.
Mr. Chairman, and for Mr. Dink particularly, and Mr. Bradley and you, Mr. Gallagher, I do want to emphasize this, the XRF gun test, that test scientifically was all the way deep, and you don't need to redo that. That doesn't need to be a snapshot because that stays the same. It's the dust swiping that needs to be redone because the dust has changed because something might have altered in there. So that's the part of the snapshot that you don't want to build piecemeal, as Mr. Vanover says.
But that's
the important thing is this, ask you to uphold Mr. Santillo, then Mr. Burkons, as he has had the right until now and will continue to have the right to resubmit a report. In that report, he can put the XRF that he's already done, and then he'll need to do new dust swipes, and he'll need to do anything that does need to be updated, he'll have to update. I want to make this like circular. Anything he does need to update will need to be updated. Anything he doesn't need to update does not need to be updated, can just be relisted. Who decides that? Who is the professional among us who looks through that report and determines the adequacy? It would be Mr. Santillo or Ms. Farmuth. So uphold the notice, let Mr. Burkons go back. He's not starting at square one because he can reuse his XRF, but he does need to not follow through on some items that you're listing today. He needs to follow through on the full HUD guideline, do a full report that gets fully reviewed. I don't want the discussion today to allow him a little window through. That's an easier window than the full review of his report.
Well, what Mr. Roberts has described is contrary to the HUD guidelines. That is contrary to it, which does not have this staleness quality of a dust wipe test that Mr. Roberts and Mr. Santillo are are suggesting. There is no staleness. They are allowed, in fact, specifically, they are encouraged to test, retest, and keep going until every area has cleared. How long that takes is indeterminate under the HUD guidelines. There is absolutely no requirement under the HUD guidelines to go back in time and redo a dust wipe if it was done 100 days ago or 2 years ago. There is no such requirement under the HUD guidelines. That is why this deficiency letter should not be upheld, because in the deficiency letter, it says you may not amend this deficiency. You have to go back and retest. That is fatally flawed in this deficiency letter. It cannot be upheld because it is contrary to the HUD guidelines and the requirements that the HUD guidelines and the OAC require, which is go back, clean up the failed area, get that clearance area resolved, and then you receive a clearance of your lead assessment. That's what the law says, not what we think it would be better if something that was X months or years old gets to be redone. As Mr. Gallagher points out, this 20-year test is for 20 years. And they're saying that, and a dust wipe after a few months suddenly is gonna be no good when the certificate itself is for 20 years?
Yeah, it may not be, but I gotta go over to Mr. Bradley, because Mr. Bradley was the one that was talking before. Mr. Bradley.
Mr. Chairman, can you
Yes.
go ahead and remand this back to the city? And we have plans after that, because in the essence of time, we have 19 other people here today. And we need to remand this and then we'll get it cleared up.
Well, they're all hinging on this one here, Mr. Bradley, I do believe. So, you know, what we come up with, what we decide is, and my question is to you, is that we need 100% on the board in order for it not to be remanded. If your opinion is that we should remand it back to the city and uphold it, then this ends up being, well, it's not going to go through, regardless of what I think or Mr. Denk thinks.
The tenant is in danger with the lead in the building. The tenants have to move out of the building until it's cleared up, then we can get it cleared up.
Right, and I think the requirement or what's being asked for by the city is that a whole new, this to redo it all and submit it in as one report.
Yes.
Okay, and that's what the city is asking for and requiring.
Yes.
Is that your understanding?
Yes, it is.
Okay,
Mr.
so
Chairman,
who is this?
this is Mr. Vanover.
Oh, Mr. Vanover, go ahead.
So the appellate has appealed our notice of deficiency. And your legal counsel can opine on this, but my understanding is that if the board does not agree, then their appeal is denied. Is that accurate, Mr. Chairman?
That's my understanding, yes. And our attorney can respond, but that's my understanding.
That would be accurate. For guidance for the board members, are you, the appellants, Mr. Chair, to the appellants, able to point out to the specific provisions of the OAC and the HUD guidelines that encourage retesting?
Absolutely.
And that board members might provide some guidance as well, since the reports are based on HUD guidelines. Mr. Santillo's conclusion was based on HUD guidelines, and appellants are alleging both the HUD guidelines and the OAC encourage retesting of specific areas as opposed to a new inspection as stated in the deficiency report. That might perhaps help the board members, Mr. Bradley, Mr. Denk, and Mr. Gallagher, deliberate on, rather than me going through this dialogue, which I'm not familiar with, and the guidelines were not submitted to us before. So if you could provide the specific sections that you were referring to.
I would be happy, and I thank you for the opportunity. For the Ohio Administrative Code, and I will include a copy of that code section for the record. It's OAC 370-32-12, which deals with clearance examinations. And in section E3, I'll read it into the record. Do you prefer that Mr. Burkans read into the record, or may I, sir?
Either.
Okay.
Both.
If one or more environmental sample fails to meet the clearance standards established in Rule 3701-32-19 of the Administrative Code, additional clearance examinations of the property must be performed until the clearance standards are met. For a failed dust wipe sample, all the components represented by the failed sample shall be recleaned. Additional clearance examinations of the residential unit, childcare facility, or school shall be conducted in accordance with paragraphs E1, E2, and E3 of this rule, except only those components or areas requiring additional cleaning or other correction are part of the clearance area. So that's talking about that. In the HUD guidelines, I refer the board to chapter 15, subpart Roman numeral 9, dealing with interpretation of clearance results, recleaning, and resampling. Specifically, the section 15-39. In 15-39, right there, says under C, recleaning and resampling. 1, single surface clearance sampling. Now, this is different than the next section dealing with composite clearance sampling. Mr. Burkans, and in fact, in the state of Ohio, I believe there is not composite clearance sampling. So the only thing applicable here and to be reviewed is number 1, single surface clearance sampling. And that says if single surface wipe sample leaded dust levels equal or exceed those in table 15.2, cleaning and sampling must be repeated until compliance is achieved. The clearance examiner should explain to the client what surfaces must be recleaned in what rooms. The recleaning should be focused on those types of surfaces where the sampling results indicate that the previous round of cleaning was inadequate. For example, if floor-leaded dust levels are above the standard, but interior window sills and window troughs are below the standard, only the floors need to be recleaned. Similarly, if single surface samples fail in one room, then only that room and any rooms not sampled need to be recleaned. If composite samples fail, which we don't do in Ohio, then all the surfaces the composite represents need to be recleaned or resampled. They don't do composite surfaces in Ohio, so you don't have to worry about that. So what I've recited are those sections of the HUD regs and the OAC, the Department of Health regulations, that require recleaning and resampling of only the affected areas. You'll note there is nothing in what I have read in those HUD regs that talks about the identification of excluded components. It's not in the HUD regs.
Okay.
Or the OAC.
Mr. Chairman, if I might briefly respond. What does all of that mean? Here would be my point. What all of that means is a live issue that could be subject to debate. So the procedural way this should work is he submitted a failed report. You uphold the city's report, and then he resubmits, he reads those, and he follows those, and he resubmits based on those. And Mr. Santillo, based on those, will review that report. Now, we can guess there's gonna be a dispute because they believe that that's an endless chance to reclaim. And the city's position is it's not an endless chance to reclaim. So that's a dispute that you may well hear in the future, but it's not before you today. What's before you today is the failure to test all the components for XRF, supporting the denial that Mr. Santillo did. Don't tamper with the future by telling us how to run the report. Tell him how to do the report. He's going to blame you when he does it the way you say, and then it doesn't get approved. Just say this: upholding the notice, he can redo the report. He can follow the HUD guidelines when he does redo the report, but he needs to submit it to the city. The city will review it. If we see the HUD guidelines differently, we may deny it. Then he can bring that before you on appeal. And then you would be foursquare faced with the question of what those things mean that were very complicated and contextually not, Mr. Bain didn't read the context of all those. So we can have that debate a later day.
Well, let me just respond very briefly to Mr. Roberts, because he's misconstrued, respectfully, Mr. Roberts, what is going on here. He is asking you to uphold this deficiency letter. This deficiency letter does not identify anything being missing. Mr. Burkans has testified that he complied with all aspects of the HUD requirements. That is what the law requires him to have done. That's what your own 365 requires him to do. Comply with HUD requirements. He has done that and he has testified to that. The city has now come and said, well, you did not identify excluded components, which was not part of the HUD requirements, but that after this test, we are now issuing instructions to assessors, you must identify excluded components and retroactively consider them in a report that you did months before we made that requirement as a city, which is outside the HUD requirement, so it's outside their own set ordinance. They can't do that, first of all, and there are lots of reasons, constitutional being mostly. You can't retroactively, ex post facto, change a criminal statute in its enforcement and what it says, which is what 365 is. It's a criminal statute.
All right, so.
And let me just, and in the deficiency report, what it says is not simply retest. It says, and I appreciate Mr. Roberts inviting Mr. Burkans to start all over, because what this deficiency letter also says, which is, again, not according to HUD regulations, which I just read to you, the existing inspection report may not be amended, and a new inspection is required to document the correction of the observed deficiency. Nowhere in that, what I read to you from the OAC or the HUD reg, does it say a new inspection is required to document the correction of the observed deficiencies, and this report may not be amended. Nowhere does it say that. And that is more, that's just extra legal. That has nothing to do with enforcement of the HUD reg, which the city is obliged to follow.
So, Mr. Bannon, let me run this by you. So if we do just kind of what Mr. Roberts was saying, let's say we uphold the notice of deficiency, remand it back to building and housing, you follow the guidelines of the state, okay? And what it says and what you have read to us, and you return back in whatever areas were deficient. And then if again, they say, no, that's not good enough, we need the whole report, then you can appeal that. And we'll have to hear it, okay, on appeal. So that's basically what I'm saying, is that if we do this and if you follow, you're going to follow that because you haven't done it. You haven't submitted in for those areas. I don't think in any of these properties, but if you do that and follow what the state is saying, and then if they say, no, we don't agree with that, you have to redo it all, then that's an appeal.
You mean 2506? You mean appeal to this?
Mr. Roberts?
Mr. Chairman,
to this.
Would,
Yes.
these people are living in they're renting a building with lead. All we need to do is get the lead, clear the building of lead, and we'll be finished. That's what our meaning is, to clear the lead out of it.
Right, but they're saying they want the whole thing redone when he has some of it's already been done and passed, basically. I could say passed,
Whatever they have
but
to do is get
not
it
really.
free. That's what we're asking.
Mr. Chairman,
go ahead, Mr. Vanover.
so perhaps to provide some clarity, what we're hearing here is an argument from Mr. Burkons and from his representative that they followed all of the HUD guidelines. And they don't want to retest everything for the areas that we've stated they did not follow the guidelines. But they don't need to provide us an exclusionary report. So we're saying they didn't follow the requirements, that they didn't test all the areas. That's part of it. And they're saying, yes, we did. And your position is to test those areas that were not tested. And they continue to say there's no requirement for an exclusionary report to tell us what they did not test. So I agree, of course, with Mr. Councilor Roberts, that they can test those deficient areas, that they're not going to tell us what they didn't test because they feel that there's no HUD requirement to do that. Submit it to us, we will review it. And then there's the specific issues that would come before this board. Or the city's going to ask that the Board of Appeals enumerates in the resolution every area and every test that they're allowed to reconduct. And we'll have no other choice but then to put it on the board, for the board to name all the areas and all the work they have to do, because they're not going to provide us, or feel they don't need to provide us, with an exclusionary report. And then, without getting into 800 pages, that may be true. But if the board's going to rule that they just have to test those areas that they haven't and deal with the deficiencies, we're going to ask the board to enumerate all of those areas in the resolution. And,
Well, Tom, what I'm saying is that we would uphold the notice at this meeting and do that and remand it back to you. Then they're going to take a look at it, and however they submit it, however they feel they can comply with the Ohio law, because they haven't sent anything, I don't think, back in on those areas, or retested on those areas that failed, from my understanding. And so,
you're correct, Mr. Chairman, but they're arguing that there's no areas to be retested.
well, there is areas.
Mr. Gallagher, that is, let me cut through this. If it is, and I sense that on this appeal, it is the inclination of you, at least perhaps, in what you're saying, to uphold the deficiency. What I would ask is, if you do end up concluding to uphold the deficiency, that you do not uphold that portion that says the existing inspection report may not be amended and a new inspection is required to document the correction. That is the language that collapses the ability of Mr. Burkons to make an assessment of this vaguely described deficiency areas, of not enough XRF areas, whatever that means. Okay, if we've narrowed it in the course of the testimony of this hearing to be, excluded areas, and that he'll, provide the city, this is what we've tested, here's excluded, because that's their new rule, whether it's legal or not. That's their rule, and Mr. Burkons has been complying with it in tests that he performed after that rule was emailed to assessors. Even if it's not legal, he's been doing it. For this, the truly offensive language in this deficiency letter is this prohibition and instruction that the existing inspection report may not be amended, even though Mr. Centillo initially allowed it to be amended. What we're asking is, if you're going to uphold a deficiency letter, which we don't think it should be, that a carve out is made and that you overrule this language that says the existing inspection report may not be amended. Because it's only with an amendment to that can Mr. Burkon succeed in testing whatever other areas can be identified that were not tested. His belief is he tested any area that under the HUD guidelines that had to be tested. He can go back to the building, and if there are no baseboards, he'll say, he'll say the negative in an excluded report. I did not test baseboards because there are no baseboards. I did not test the floor because the floor has vinyl coating on it, covering on it. I did not test the ceiling because I can't reach a ceiling. He can say that, but first he has to be able to amend this report as he has been permitted to in the past, as Mr. Centillo, in fact, encouraged and allowed him to do for this very report. He has to be able to do that for this to work at all with what you're considering, Mr. Gallagher.
Okay, Mr. Bannon, what I would say, I'm not gonna carve anything out in the motion. I'm gonna state it plain and simple that we would uphold this and remand it back to building and housing, and then this may end up in court, I don't know. Or we can come back and you might have appeal on again, but I can't take and say specifically, kind of like what Mr. Vanover was saying. I mean, I can't do that, okay? But what I'm gonna do is I'm gonna put a motion up. And then depending upon what you want to do with the rest of these cases, this is only gonna hinge on this case. You may want to not have them heard, I don't know. It's up to you because we only have 3 board members, okay? So I'm making a motion to uphold the notice of the deficiency and to remand it back to building and housing for any further action.
Move.
Okay, moved by Mr. Bradley,
Second.
second by Mr. Dank.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, so that notice goes out in 2 weeks. Now, the question is, with just having the 3 board members, Mr. Bannon, do you want to go on and hear the rest of the cases?
It's to you.
I'm sorry. The last name is Bain, B-A-I-N. I'm sorry, I didn't understand my name when you said it. Could I take a moment to confer with my client, please?
Sure, go
In
right
that
ahead.
issue? Who are we missing from the board?
We're
Mr.
missing Mr. Maskey. Mr. Maskey is he is our architect.
Oh, okay. If we did not proceed today, when would we be able to proceed with a full board?
To Mr. Chairman, to the appellant's attorney, you probably would not be back on our docket until maybe June of this year. We have, I pre-scheduled you, originally in November 22nd of 2023. It was understanding that you could not meet at that time. Our other dockets are filled up with the railroads and bridges that was cited by the city. We have over 100 cases of those that we already have preset with the attorneys, and they booked those out so they would not be in court for those cases. So they start February 28th all the way up to April of this year. So we would not be able to squeeze you in until probably late May or June.
Okay, if, could I have like 3 minutes or 4 minutes to break and?
You
Before I
can,
get-
but before you leave, Mr. Vanover, do you have a question? Your hand's up.
No, Mr.
Okay.
Chairman,
He's good.
I do not. I'm good.
Okay, all right. Go ahead, Mr. Vanover.
Okay, thank you. I'd like to be able to confer and be
Sure.
offline to do it.
You go right ahead.
You guys, if you want more privacy, you should go out those doors.
Are we muted?
Are we muted?
Okay, well, permanently.
Mr. Chairman? Am I back on? Oh, we're waiting for that guy.
We're muted.
We are
Oh,
muted.
okay.
Are we-
Mr. Chairman?
Hi, can you hear me?
Yes.
Okay, with all respect to the board and in consideration of your time, and because these are involved, as we see, it is the preference that we proceed with a full board. So hopefully we can get this thing, we'd like to work with the city and the scheduling secretary to come up with an available date that we know will work for everybody. So it's not, a date that on reflection by any party is seeing that it doesn't work. So we'd like to work with the board's council, city's council, and myself to make sure that we have a collaborative process to come up with a meaningful date that the board can be present and all the parties can be engaged. So with that, we will move on with, you've made one decision today regarding this property, and the others we will hold in abeyance with no prejudice to the appellant, I'm assuming, and we'll see you at a later date. I appreciate
Okay.
very much. I appreciate, let me say, the attention that the board and the time you gave to hearing the arguments and evidence today. Thank you very much.
Okay, very good. All right, so that kind of cleans the docket and relieves anybody who was on here to testify. And so if we don't have any objection, that will clear it out, and they'll be rescheduled. Thank you. We do have some more business.
Yes, we do,
Take care.
Mr. Chairman. Approval of resolutions and approval of minutes.
Okay, we're gonna get to that right now. Okay, approval of resolutions, A 142-23, A 164-23, A 167-23, A 175-23, A 176-23, A 182-23, A 183-23, A 195-23, A 225-23, A 358-23, A 359-23, A 406-23, A 408-23. Motion
So move.
moved by Mr. Bradley,
Second,
second by Mr. Dank.
Mr. Bradley?
Yes.
Mr. Dink?
yes.
Mr. Gallagher?
Yes. Approval of the minutes for January 17, 2024. Are there any additions or corrections?
No.
Motion,
Moved.
Second.
okay, moved by, I'm gonna be forgetting everybody's names here, Mr. Dank, and second by Mr. Bradley.
Mr. Bradley?
Yes.
Mr. Dink?
Yes.
Mr. Gallagher?
Yes. Is there any other further business to come before us?
Not at this time.
Okay, we are adjourned. Thank you.
Listen,
Thank you.
I need to ask Tom a question,
Okay, well, I'm gonna leave. You can go ahead.
huh?
Are you calling him or you wanna ask him?
I want to ask him.
In public, we're still on.
1 second. Could you stop the live, please?
Yeah, we did. We moved it to evidence.
Need it. They need to include this in their record.
Well,
What document is that for?
That was the example.
Is this the one you gave for?
The host, just give me Tom's, cell number, please.
we stopped live.
Let me make sure.
Oh.
I hit pause, but I don't know if it is pause lines.
No.
You want this submitted for docket 218 or for all of your?
All of them.
Oh,
Okay.
Give me one moment.
What's that?
We have that copy.
Yeah,
You can-
you can have it. Well, we'll have to get it back. What you're gonna see is that we just ask for it. It's not in that report that's approved at all.
Yeah, I'm just gonna end the statement and pick it back up.
Okay.
Mr. Vic, Brandon, is that provided as a police, someone that is